Information Risk with David Lotion, powered by Insight Jam.
Hey, it's Doug Atkinson here at Solutions Review, and we are back with another episode of the Information Risk Podcast with David Lotion. David, of course, is Solutions Review expert and also the principal analyst at Knowledge Integrity. David, thanks for being with us.
Thanks for having me. I lost my window here, so if my eyes are darting around, it's looking for. Oh, there we are. Thank you for having me. I'm back.
No worries. It's always good to keep you on your toes.
Absolutely.
So there was a news article that I thought was interesting a couple of weeks ago, and that was around some legislation that has been drafted for a comprehensive data privacy law, the American Privacy Rights Act, for the United States to get into the GDPR business, if you will, and really try to go nationwide and really give Americans the ability to enforce their data privacy rights. And I'm curious, I'm sure you saw that, but I'm curious your perspective on the whole data privacy legislation movement, data privacy laws in general. I mean, give me your take on where we are, and we can get into a little bit of where we're headed.
Absolutely. I mean, you've picked one of my favorite topics because data privacy policies are probably the most broadly defined manifestations of data management directives that are imposed by authorities that have a right to be able to do some kind of compliance and enforcement factor, and it's driven by a bunch of different things. Maybe I can kind of riff on that a little bit. That essentially, I think that there's maybe 2 or 3 factors that have created this demand for legal qualification of imposition of rules about data protection. And I think the first is the proliferation of the use of online, e-commerce and data collection activities that go along with that up until the internet became the World Wide Web and became, pretty much ubiquitous. It's not like companies weren't collecting customer data or person data and using it, for their own marketing and sales purposes. It's just that the scale of it, ratcheted up by orders of magnitude because of the availability of the data and of the core operational mechanisms of how the World Wide Web works and how e-commerce works, which is you've got lots of people who are executing transactions based, that are driven in relation to their own identity. So, it's one thing when you've got, and I think we've used this example before, in the olden days when there was, Sam's General Store up next to, the saloon in some small, town in out in the wilderness. Sam was a guy who was standing behind the counter, and when people walked in, Sam knew everybody who lived in the town. So when Mrs. Jones walked in, he'd know that it was time to get 2 pounds of sugar out of the sugar bin and a couple of sacks of flour because he knew that she did a lot of baking. And when Mr. Smith came in, he knew that he had to go to the back to the horseshoes and grab some horseshoes because it was that time of year for horses to get shoed. So it's not like there wasn't awareness of your customer domain. It was on a very small scale. It was hundreds of people, maybe even thousands of people, but not hundreds of millions of people. The difference is that, and then we can look at other data aggregators, data collectors over time. So, you got your Nielsen's and you got your Merkles and those kind of companies. And what they've been doing is they are, like Nielsen's a good example. They send out these logbooks for people to mark down what kind of television shows they're watching and what time they're watching and when they're watching. And ostensibly it's for monitoring the who's watching what and how to rate the quote unquote attendance of those television programs. But while they're collecting all this data, they were collecting aggregate information about the individuals who are watching those types of television programs and be able to monetize that some other way. So a lot of the marketing companies, this is not new stuff. They've been doing this for 50, 60 years. It's just that it was relatively time consuming to assemble this kind of mode, and it wasn't so insidious, in a way that people get creeped out. It was that I did get a letter offering for me to buy some kind of product, but like I like getting mail, and it was interesting to see it and all that, and then it turned into this flood. I would say this started maybe 30 or 40 years ago, the flood of catalogs, and that database marketing became a thing, and people were getting catalogs, and most people just throw them out, and that was pretty much it. But the ability to do targeting, and this is what we were kind of chatting about, in one of our prior episodes. So if you haven't seen that one, that's the one. Go click on the show and go back to the one about target, where we're talking about collecting money and being able to do inferencing of information about customer behavior. So all this stuff, suddenly, people don't mind it until they start getting creeped out by it, and that, that's one factor, is that all of a sudden there's a lot of advocacy that is notifying people that, hey, wait a second, yes, you are getting this level of convenience because you are signing up for a free email account, or you're logging into this thing, or you're buying your stuff through these e-commerce sites, but realize that they're just taking all your data and they're turning it into methods of trying to sell you more stuff. And some people don't have a problem with that. And I talk to people all the time who say, I don't really care what they know about me.
Well, I think there's another element as well. And that is, not only are there lots of data sets that are able to market to you and potentially without your permission send you marketing offers, but there's also so many iterations of your data, sometimes extremely sensitive data that's out there that is being breached. I think that's one of the biggest reasons why I think the Congress is getting involved. I mean, you just type in data breaches into Google today, and it's Pfizer notifies millions of members of a data breach. AT&T data breach affects millions.
Right.
United
so
Healthcare,
you
protect
you
your
anticipated
data.
what I was going to say.
United Systems of Georgia, a local credit union in Massachusetts, cyber attacks in Montclair, New Jersey, ring customers to receive $5.6 million in privacy breach settlement. So that's just
one of my favorite ones.
That's outrageous.
One of my favorite ones is the Marriott reservation system hack in 2018, where 500 million guests' private information was stolen. Another one, I'm looking at this one. Let's see, 885 million sensitive financial records were left exposed by First American on public servers, where anyone could access them until May 2019, including social security numbers, tax documents, and more personal information. We've all been breached so many times. I mean, it's outrageous. I mean, the idea that we haven't, everybody has been breached multiple times. Right.
Times.
I mean, I always say, you either work for a company, or you do business with a company that's been breached, or you do business with a company that hasn't yet realized that it's been breached. but it's constant and continuous, and has created this other problem, which has become the identity theft business, which was pretty rare 30 years ago. And now is not only is identity theft, so the theft itself is the business, right? Is the stealing of information and marketing the data, selling the data, and then whatever fraud people do to steal your identity and get money and do whatever. But then the whole ecosystem around protection against identity theft is a huge business that didn't really even exist. I mean, maybe there was. But it used to be. There's a problem. You contact the credit bureaus, and you get it fixed.
It's incredibly. Truth be told, it's incredibly unsophisticated, and in comparison to the bad actors that are out there, and this is the other threat that exists now is that the bad actors are getting more and more powerful tools. You overlay AI and you overlay some quantum computing that's coming down the road. You just overlay all the various nefarious tool sets that you have access to. I mean, there was a breach of the entire tool set of the CIA. The whole CIA tool set went out the door at one point.
Yeah, and it's like, it's astounding. It's not even that. It's that it's funny because the mechanisms that people will go to facilitate or enable, the theft of information, of personal information, it's not sophisticated from a technical point. It's sophisticated from a behavioral point, which is that I know really smart people who have fallen, victim to infiltration. And it's funny. There's this guy. Many people who are listening to this may recognize the name Kevin Mitnick. He was like this notorious hacker in the 70s or 80s. Notorious so much that like when he was like one of the, like the original phone freaks, PHREAKS, where they would get their hands on manuals from AT&T and they would make use of all that stuff to be able to figure out how to make long distance phone calls without having to pay for them. And this is a guy who, when he was arrested, he wasn't allowed to make a phone call because they were afraid that he wasn't going to call a lawyer. They was just going to use it to hack into some other system. So this guy, and I'll give him credit because he I think he went legit and became a what's it called, like a security consultant.
Yeah,
after he was released from jail. He was in jail for
I think they probably cut a deal there to have him help.
Yeah,
Catch Me If You Can there. What?
Yeah, exactly. So he wrote a bunch of books, and like these books are basically like they're warnings, like don't fall prey to this. But like if you want to steal information, like buy this book because he tells you all the things that people do.
No, we get them every day in our email system where people are spoofing me, asking for gift cards. Yeah, and I mean it used to be, it became the joke, right, of the internet, this idea of don't send your money to Nigeria or whatever the original kind of spoof was.
Yeah,
but now they're getting more and more sophisticated to the point where they are hard to tell that they're coming from. They aren't coming from me. I mean, I literally on an internal network will be asked, "Is this you, Doug?" And I have to tell everybody, I'll never ask you for any of that.
And this happened to me literally the other day. So like I have an accountant who does our tax, does our corporate taxes and does my personal taxes. And I got an email the other day and it legitimately looked like his email. And it said, "Oh, here's some additional stuff. I actually went through your tax filings and redid your 2020 taxes. Please go to this folder and review it." And I looked at it and I said,
"It is the folder."
It's usually I'm pretty good at like immediately spotting, but I had to look at it twice.
Yep.
And I actually forwarded it to him and I said, "I'm just verifying this is not you, right?"
Yep.
Like, and he said, "You're correct." But like he was hacked and his email was taken over, and then somebody created a new email. They stole all of his contact information and created a new email address, and then starts spamming out emails. So this is a topic that is ripe for yet another conversation.
Yeah, no, and I don't want to get off topic.
And I don't want to go.
We could talk about breaches and spoofing and all the various phishing and so forth.
But that would not distinguish our podcast from all the hundreds of others that talk about that.
It is, but it is a cautionary tale for the impetus to develop nationwide
these
privacy laws, which
privacy laws are ubiquitous. I'm looking at a paper right now. We'll put the link in the information there. in 2023. The title of the paper is Global Data Privacy Laws 2023. 162 national laws and 20 bills. And it basically says, they're saying since 2011, they've made a biennial assessment of the growing number of data privacy laws and bills across the globe, blah, blah, blah. By January 2021, 145 countries had enacted data privacy laws. Another 12 did so by mid-2022, bringing the total to 157. Each of these is described in a separate article, so those are all available. And then, between that time and January 2023, another 5 countries. By the way, none of those countries is the United States. So, how you triggered the conversation about the U.S. privacy law. It's interesting because they've been talking about that, I would say, for about at least 5 years. And there are numerous state laws. So Virginia has a state privacy law, and Colorado has a state privacy law, and California has a state privacy law.
Yeah, Nebraska's about to pass one. There's definitely some interesting ones out there.
Yeah, so it's an interesting question about federal versus state jurisdictions and the degree to which there's oversight. And I would even raise a question that it might be an interesting conversation to determine what the jurisdictional rules are about variance in compliance between a state's law and a federal law. I would have to default to constitutional experts about that one. But
well, it's interesting. California's already making noises about this American Privacy Law Act because they think it will weaken theirs, because they're going to try to smooth it across, all the constituencies and certainly the lobbying. I can only imagine the amount of lobbyist money that's being poured into influencing any kind of national legislation around data privacy from the largest data collectors on the planet.
I would say
the largest technology firms.
If only companies would spend as much money on consulting, on data management consultants to help them. But if you are interested in that, certainly contact me, because I've been thinking about this for a very long time, and I actually understand a large number of the complexities that emerge because of the fact that there are so many different laws, and that's something that we're gonna cycle back on. But just to go back to the motivating factor, this whole thing about the difference between what I started out with, which was the creepiness of beginning to understand how an individual's personal data is being used, and number two, the whole data breach and the exposure of personal information that's led to these concerns about identity theft, and I'll pile on top of that as well, which is there's a national security threat to external, to either nefarious organizations that are not governmental or are adversaries in the world, or the United States adversaries, or the adversaries of the free world, who are continuously bombarding our systems to extract information, to then make use of that however they want to use it, but to be able to explore ways to exploit the population. And this, I think, is yet another topic that I want to cycle back on, which is the whole idea of misinformation and deliberate disinformation and influence. This, I think, is a huge risk, a huge information risk. Stay tuned, because this is it. Not only is it something that people are increasingly being inadvertently, or in a way that they're unaware of, being affected by it. It is actually going to get magnified by the existence of these generative AI systems that are just going to feed that monster. So, sit tight for that.
Yeah, and we're going to take a quick break, but I mean, just along those lines as well, there is clearly a concern at the federal level with regard to the influence of TikTok, right? Foreign-owned Chinese Communist Party influence on algorithms that are, in theory, creating narratives for a generation of users that and millions of them that could create negative societal issues in the United States that are being driven by a foreign ally, adversary, whatever partner, whatever you want to call them.
I'm not going out on a limb in saying that it's already happened, and it's already happened in a wide variety of domains, and I will leave that as a tantalizing tidbit to think about.
This is why I love this show, because we could just go in every direction possible and have all the content we need to have long conversations. So we're going to take a break. And when we get back, we're going to maybe dig in a little bit on some specifics in California.
Solutions Review is inviting you to join InsightJam.com. What started a few years ago as a social media event to celebrate enterprise technology has now grown into an always-on tech community with live events, discussions, videos, vendor showcases, and industry resources. Our vetted roster of experts, thought leaders, and analysts are sharing tips and tricks daily. So if you're interested in getting involved, join the long list of companies and brands who have already participated by visiting InsightJam.com today. Now back to the show.
All right, David, let's get into California. As many people have said in the past, and tell me a little bit about what's going on there, because there are a couple things, two acts: the California Consumer Privacy Act, the CCPA, and the California Privacy Rights Act, the CPRA. Can you talk a little bit about what the differences are there, and we'll explore a little more about where California's head's at?
So I think it's more a question of evolution. That California is a pretty largely populated state. So there's a lot of people there, and there's been an evolution of privacy laws over the years. And I think the first set of laws that were targeted at online protection were really focused on children, and the use of that companies were using data they were collecting about children under the age of 13. So there's a federal law called COPPA, which is the I'd have to look that up.
Yeah, it's a Child Online.
Child Online Privacy Protection Act, right? So California actually, I believe, had their own versions of some of these things. So there's one called the Privacy Rights for California Minors in the Digital World, but these didn't address the general issues associated with personal information that businesses would collect about those individuals and how that data was going to be used. And in 2018, there was the passing of what was the second thing that you referred to, which is the California Consumer Privacy Act, or CCPA, which was the first version of their privacy law, which basically essentially was modeled after the European Union's General Data Protection Regulation, GDPR, which went into effect, I think earlier in the decade. Which was talking about what a consumer's rights are for understanding what data was being collected about them, and whether their personal information was being used, and how the personal information was being used, and whether companies were using their personal information to monetize the data collection and be able to use it to target them with ads and be able to track individuals as they move from one website to another website. And more to the point of what we were talking about before is the safeguarding of that information so that it couldn't be hijacked for, as we were talking about before, nefarious purposes. And then by the time that CCPA went into effect, there's already people who are saying it's not strong enough. So by mid 2019 or so, there were bills that were introduced to modify or amend that law to add some additional strengthening of the consumer's rights. And that turned into what was passed in I think 2019, called the California Privacy Rights Act of 2020, which is basically a souped up version of CCPA. So CPRA is the current California privacy
That's
law.
right. The timeline, it was June 2018 for the CCPA, and then it passed in 2019, took effect on January 1st, 2020, the CPRA.
CPRA, right? Yeah, it's alphabet soup. Gets confusing every once in a while, but the main objectives of the CPRA is to give the consumers the right to know who's collecting personal information about them, about what is the personal information that is being collected, and to whom it's being disclosed, and then to be able to give those consumers the ability and the mechanics to exercise control over how businesses use their personal information. And so an example of this is let's say I'm a California resident and I'm going to a California e-commerce site and I want to order a tent. Well, first of all, when I go to the website, the company has to tell me, we are collecting your data and here's what we're collecting your data for. And this is what has become, similarly to what was imposed by GDPR and some of the other laws, the ubiquitous allow cookies, don't allow cookie, reject cookies, manage my cookies. So, if you're the cookie monster, this is like a free-for-all. But if you understand what you're talking about, most people, what do? They just click accept all cookies. But the real understanding there is that the cookie mechanism is what allows websites to track your behaviors and your activity from one website to another website, and from the same website the numerous times that you go to the same website. So when you go to the website, it is dropping a little notification on your computer that says you came to this website and what time you came to the website and what some other information about you. And that when you visit it again, it's there, and they say, "Oh yeah, welcome back." And that's why when you every once in a while you'll flush your cache.
You have to log into everything all over again.
Yeah, exactly. That is how they manage that. But when you say, the problem is it's like one of these catch-22s, which is if you want to use their site to do what you want to do, you have to accept the cookie. And if you reject it, then it limits what you're able to do. So if you can't go to the website to do the thing that you want to do, because you're rejecting the cookie, then you might as well not bother anyway. So it's
what's so nefarious is that cookie then follows you all around, all over the place, wherever you go.
Right.
It follows you. It's a little whatever they call them, persistent cookie, and it just follows you around and it hoovers in all the other things that you're up to.
Right, and it's not. And this is where what happens behind the curtain is the real interesting stuff. So it's not that you go to xyz.com and they drop a cookie and then they know that you're coming back. It's that there are these whole networks of ad servers and caches and the guts of the internet.
Retargeting.
And they're the ones.
It's all marketing driven.
Those are the guys
driven
that
by
are
the marketing department.
Yeah, and those are the guys that are doing the cookies. It's not like the canonical example is this company DoubleClick, which was the ad
bought
server,
by Google.
Which was bought by Google. And so Google is really, when it comes down to it, Google is the main dropper of cookies all over the place.
Oh, it's outrageous how much information they've hoovered.
Right. So ultimately, the goal of CPRA, CCPA and then CPRA is to allow a consumer to say, okay, you're collecting my information. What information are you collecting? So you have you have all these rights, right? I can read through some of these, and these are similar to the rights that GDPR and the Virginia law and the Colorado law and maybe Nebraska and Kenya and Singapore, and every single law is going to say what the rights are. So, for example, I'm going to read this from the CPRA. It says consumers should know who is collecting the personal information and that of their children. Consumers should be able to control the use of the personal information, including limiting the use of their sensitive personal information, the unauthorized use or disclosure, which creates a heightened risk of harm to the consumer, and they should have meaningful options over how it's collected, used, and disclosed. Consumers should have access to the personal information, be able to correct it, delete it, and take it with them from one business to another. Consumers should be able to exercise these options through easily accessible self-serve tools without being penalized for doing so, and be able to hold businesses accountable for failing to take reasonable precautions. and consumers should benefit from businesses' use of the personal information. So I kind of just rattled those things off, and I did it kind of loudly to mask out the sound of the telephone ringing in the background. So hopefully I was successful in that. But basically it says you have the right to know what personal information is being collected. You have the right to control what they are collecting. You have the right to see what they have. So if, let's say, Doug's company is collecting information about me, I could say, Doug, tell me what information about me you're collecting. You'll say, well, I'm collecting your name and your address and your age and your eye color. And I'd say, okay, show me what you've collected. And it says, that I'm 32 years old and I live in Miami and my eye color is blue. So I have the right to go back and say one of two things, so maybe one of three things. One is, you have all my data wrong. Here's the correct data. Update that in your system. Number two, or the other option is, I don't like you having any data about me, even if it's incorrect. But even if you had all the correct data about me, I don't want you having that, because those are all my personal information questions that I use for my password protect. And I don't want if somebody were able to find out what color my eyes are, they'd be able to steal all my passwords. So I could say, you can correct it or you can delete it. The other option is that, let's say you and I have a business relationship and I don't want to continue that. I want to go to your biggest competitor. And so I'm going to say, please give me all my information, bundle it up. I'm going to take it to your competitor and give it to them. So that's the portability. And then it should be easy for me to do this. It shouldn't be like I have to, make telephone calls and sit through endless automated voice trees until I get to a part where it just stops abruptly in the middle and hangs up. But rather, should be able to go quickly to some kind of website and be able to say, yeah, here's all the adjustments.
Have you ever seen that though?
Yeah.
Where it's easy to do.
Yeah, the cookies thing kind of. There's a lot of websites where you actually click on it and it's pretty easy to say.
Oh no, the cookies thing I get, but the idea of
I've never
copy
asked
of your data.
I've never asked, but this is
you've never asked.
But this,
right. I don't think I have either. We've had people ask us to delete their data, and we comply, obviously, but it's few and far between.
But what you're raising is actually becomes one of our information risks, which is if a customer came to a company and said, show me all the data you've collected on me, it means that the company's got to know where all that data is. And I'm constantly asking people, how many databases are there in your company? It's like, 5? No, like hundreds or thousands. And how many spreadsheets are there? And how many emails are there? And how do you keep track of all of that? To me, that creates a huge information risk, because if I cannot track down every single piece of information that any consumer might that I might manage about any consumer, then I'm at risk of being non-compliant with the law.
Correct. And it's interesting because then there's a liability issue with regard to your housing my data if you're the business and I'm the consumer. And I'm curious whether there's any teeth there at all with regard to, is anybody concerned about the liability? I get the idea that there's liability, or at least there's implied liability and potential liability, but has there been kind of a proper, I don't know, reckoning around that?
So I'm gonna pivot for a second back to one of my other notes that I had taken. And yes, there have been situations where a company has been fined for violating some aspect of a data privacy law. So I'm just going to quickly read from this. Facebook, it looks like they were fined $2.2 billion for storing passwords insecurely. Google was fined $57 million under the data privacy law. I guess my question is,
but that's
if Facebook or Google, is that really a risk?
Well, and this is where I'm at, right? The idea that it has always felt to me like GDPR was passed as a revenue generator for the EU. that they passed it in order to go suck out fines from the largest technology companies, and they have. I mean, let's face it. If you look at I won't Google it right now, but I would wager that the litany of decisions against corporations are massively top heavy against the largest technology firms. I mean, I know it all. I'd hate to be cynical like this, but I think it was just a money grab.
Yeah. So I, I'm hesitant to wander into that
that's
area
why you have
of the
me
playground.
here, David. That's why I'm here.
Right. It's okay if you say that. I'm not sure I'm going to say that, but I will say that I think that they're like in some of these laws, I think there are exclusions based on the size of the company. So it could be that if you are a company that is smaller than some number of employees, then you might be excluded from the protection of employee data rule. Like it's in there. I don't have time.
Yeah, no,
as we are talking to scan through it and talk at the same time. But so again, I guess we could revisit that at some other point. But this in its own right. I mean, I think what's kind of interesting is to compare some of the aspects of a law in California with like the law in Virginia, and just as one point, in the California law they do an enumeration. Let me see if I can find the exact wording here. It's they say, what is the definition of personal information? So of course that phrase occurs 436 times in the document. So I'm unlikely to rapidly find the definition of it here, but I have it noted on another note that I had taken. And it says, this may be from the earlier version. It says personal information means information that identifies, relates to, is reasonably capable of being associated with, or could be reasonably be linked directly or indirectly with a particular consumer or household. Personal information includes, but is not limited to, the following if it identifies or relates to, describes, is reasonably capable of being associated with, or could be reasonably linked directly or indirectly with a particular consumer or household. And then there's a list of all the different types of data entity types: name, alias, postal address, account name, social security number, other personal identifier, email address, online identifier, IP address, driver's license number, passport number, electronic data, audio data, visual data, thermal data, olfactory data, products or services.
Olfactory data.
So yeah, like how you smell.
I don't know that I want my olfactory data out there on the
yeah, I mean, it might
internet.
be, there may be companies that are collecting your olfactory data. Products or services purchased, products or services obtained, products or services considered, purchasing history, personal property records, consuming history, interaction with an internet website, search history, browsing history, biometric information, geolocation information, education information, employment-related information. Inferences drawn from any of the information identified in this subdivision to create a profile about a consumer, reflecting the preferences, characteristics, psychological trends, predispositions, behaviors, attitudes, intelligence, abilities, and aptitudes.
Which is why they're doing it. All that you just read at the end is why they're doing it.
Right.
They want they want to create inferences. They want to predict and create some sort of a scenario that can,
of course,
get you to buy more products.
Yeah, but I will give these policy wonks some credit in that they actually enumerated all the different types, and then still had a bucket for anything else that you can do and any inferences that you can draw from this information. I mean, like search history and browsing history, yeah, for sure. I mean, that's covering all that cookie stuff. So in the California law, they're very explicit about that. Now in the Virginia law, it says so note how long I was reading there. Virginia law. Personal data means any information that's linked or reasonably linkable to an identified or identifiable natural person.
Yeah, right.
Yeah,
That's
then it says
pretty
sensitive.
vague.
Yeah,
Which,
it's vague.
which,
Then it says,
which the lawyers would have a field day with.
yeah, but then it says sensitive data, which is quoted. It says means a category of personal data that includes personal data revealing racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexual orientation or citizenship or immigration status. 2, the processing of genetic or biometric data for the purpose of uniquely identifying a natural person. 3, the personal data collected from a known child. Or 4, precise geolocation data. Consumer means a natural person who is a resident of the Commonwealth acting only in an individual or household context. It does not include a natural person acting in a commercial or employment context. So that's it. And they talk about sensitive data. And by the way, another shout out back to one of our earlier episodes. It talks about personal data revealing racial or ethnic origin, even though that in the Consumer Finance Protection Board, they have a law. There's a rule that says that if you want to loan out money, you have to ask the borrower what their racial and ethnic origin is. So one law somewhere is asking for that data, and another law is saying that you can't.
Let's not.
You can't.
Now you're gonna get me to touch the third rail here. You can't now. We can't go down that path of government's left and right hands not knowing what's
right. But the point that I want to make is not the difference between California and Virginia specifically, but the variation between, like I said, there's, what did we say before? 162 laws. And that doesn't even include the state laws, or maybe it does. I'd have to read the paper, but 162, it's hard enough to manage one. And now, a company has to navigate, if you want to do business globally, now you've got to navigate, no matter where you are, there's a different law.
But there, as we all know, as anybody who's surfed the web, there is now all kinds of preemptive consent being requested for every cookie that you receive. So, which is, I'm sure, designed primarily to protect any claim under these laws as well. We got their consent prior to any cookies landing on
that. I think it's largely driven by GDPR, and that if you started to drill down into the difference between the individual countries, so Europe is Europe, so all the countries in Europe are Europe, but all the the Asian countries and South American, I'm sure if you're a global company, you're a Fortune 100 or Fortune 500 company, you got to figure this out. And I'd be pretty surprised if there's any company that can come up and say, yeah, we have a mechanism for exploiting the data to the degree that which we can legally, yet we still guarantee protection under every single law for all the jurisdictions in which we do business.
Yeah, so David, we're going to take a break here, and when we come back, we're going to get into our final act, which is really around data sharing and what happens with regard to what we will allow and what the laws will allow.
Want more Insight Jam? Follow us on Instagram for exclusive content like a daily dose of best practices and buying advice from industry experts and leading solution providers. Or subscribe to our YouTube channel for long-form highlights from our expert panel discussions. And if you prefer to listen, please rate and review the Insight Jam podcast on Apple, Spotify, or Google. The Solutions Review team is hard at work collecting the best enterprise technology information from around the globe, so don't miss out. Now, let's get back to the show.
All right, David. Final act. Let's get into what's happening under the sheets, if you will, with regard to data sharing and some of the other information risk that takes place when data is available.
So let me refer back to my original analogy, which was in our old-fashioned general store in the Wild West. And the guy who runs the store, he knows his customers, and he happens to know that some of the customers are coming in and they're asking for bullets. Now, he doesn't sell bullets, but he knows which customers want to buy bullets and which ones want to buy guns. And there's a guy who runs a gun shop up the street. So he goes to the guy at the gun, at the gun shop, and he said, "Look, I know who in this neighborhood wants to buy guns and wants to buy bullets. I'll tell you what, if I tell you who those people are and they buy guns and bullets, give me 10% of what you sell, and we'll call that an equitable deal. So like you sell more bullets and guns, and I will get paid." So basically, the guy's getting paid for selling
his data,
his customers' data, right? Well, the Old West data. So this is a model that companies have been doing for years, which is they are aggregating, or collecting the data associated with the transactions that their customers have made, and being able to monetize that by packaging it up as some kind of product and selling it to other companies. So some obvious examples are companies that are like in the financial business. These are you wouldn't look at this the same way, but obviously a company like a Dun & Bradstreet, they're collecting information about companies and selling or licensing that data. There's other companies that are collecting information about, transactions and analyzing that and providing results back. Even the census is sort of like that, but they're not selling the data, they're collecting it and they're providing it in an aggregate form.
Well, and to use your original example of the Old West, right? I think the biggest concern that people have is it went from a relatively simple value share, right? I mean, I know Tex down the dirt path is interested in guns and bullets, but what you didn't know was whether or not Tex, some of Tex's darker secrets, if you know what I mean, which you can now overlay by basically seeing Tex's browsing history, and all of a sudden Tex is a far more colorful character.
Interesting guy. Right.
Than just the guy who wants guns and bullets.
Right. So, I mean, to carry that through, it's like all that information now, if I am Cambridge Analytica and you're Facebook, and Facebook, and Cambridge Analytica have a deal where they, quote unquote, like license or provide access to that data, and then it uses that plus data. It's aggregated from other data sharing opportunities, and now what it's done is created profiles that could not have existed in any of the originating organizations, because you can only do this if you collect the data from a variety of organizations and be able to use the analytical models that allow you to make predictions about the predispositions of certain individuals, with respect to both their purchases of butter and guns, not only based on their purchases of butter or only on their purchases of guns. So companies are always looking to leverage their customer information bases with other data that they can get, and whether that's from an aggregator like Nielsen or Merkle or Axiom or any of those, or whether it's through these arrangements, corporate to corporate. That's where they're trying to leverage those opportunities. Now the problem here is that I didn't tell, like when Mrs. Jones wrote in and said, "Hey, you got any bullets?" Like, she didn't say, "Oh, and by the way, if you don't sell bullets, go sell my information to the guy up the street who sells guns and bullets." She was just asking, maybe she wanted to buy some bullets as a gift for her grandson or something. So the ability of companies to take data and then draw inferences from it that are not necessarily based on valid assumptions becomes a problem, right?
It was reasonably innocent, and it became more and more complex to the point now where, you can't behave online in the way that most people are behaving online and not completely reveal yourself
right
in all of your glory.
So this is
to a
where
data
this whole
set
question.
that can be then, I mean, honestly, it gets into way more interesting. I mean, you were talking about disinformation earlier. You were talking about other things. I mean, there's concerns in China right now around your social credit score and whether or not you're allowed to use certain elements of the public infrastructure if your credit score isn't at a certain level, which means you have to behave in certain ways in order to keep your data set in compliance at a level. I mean, when you start to overlay people's religious interests, their sexual interests, their political interests, this gets pretty dicey. And it gets, I mean, it gets far more complex with regard to how you can then begin to potentially profile and restrict people's behavior online.
Yes. And that's the purpose of one of the sections of the CCPA, which is, I can go, if I do business with your company, I can make a request from you that says, do not use my data for the following purposes. But if you are sharing my data with another organization, that's now out of your administrative domain. So because it's out of your administrative domain, what's my ability as a consumer to ensure that my data is not being used for some purpose for which I don't want it being used? And that's what this particular section, which is Section 4, which is really Section 1798.100 of the Civil Code, which general duties of businesses collect personal information. I'm going to read this. It says, this is Section D. It says, a business that collects a consumer's personal information and that sells that personal information to or shares it with a third party or discloses it to a service provider or contractor for a business purpose shall enter into an agreement with such third party, service provider, or contractor that, one, specifies that the personal information is sold or disclosed by the business only for limited and specified purposes, obligates the third party, service provider, or contractor to comply with applicable obligations under this title and obligate those persons to provide the same level of privacy protection as is required by this title. 3, grants the business rights to take reasonable and appropriate steps to help to ensure that the third party, service provider, or contractor uses the personal information transferred in a manner consistent with the business's obligations under this title. So there's more to that, but I'm going to stop there for a second, because what it's basically saying is that, you and I have an agreement. You're the business and I'm the consumer. You give me I get the right through this law to tell you how I want you to use my data. And if you are going to share that data, and I haven't said do not share the data, but I said I don't want you to use it to try to encourage the sale of firearms. It means that if you go to the gun store and you sell that data, that you have to tell them that here are all the individuals who have expressed some level of preference about how their data is to be used, and you need to observe those preferences. Now that what that does is it changes the nature of data sharing, because in the old world with no protections, data sharing means if I want to share data with you, I go to my database, I run a query, I save it as a CSV or save it as a data file, and then I transfer that file to you, and we're done. It's just a transfer of data. But in a world with a data privacy law that such as this, that has the imposition of assurance of the obligations, data sharing is now coupled with, the extraction of the data and the transmission of that data is now coupled with a bundle that I'll call it a backpack. It's got all the obligations associated with the data that's being transferred. So it means that if individuals have expressed concerns about what data is being shared and the quality of that data, then the third party also has to provide the original company's consumers with the ability to go in and do what they were able to do before, which was request to say, what information do you have about me, and show me that information and let me correct it. and allow me to opt out of your using it. And now it creates this weird burden because
it's completely unmanageable. That's completely unmanageable.
Right. It's completely unmanageable. Now, that's California. And now, again, let's magnify that by 2 orders of magnitude, because there are...
I mean, you would hope that businesses just throw up their hands and say, we don't want anything to do with it, so we're not sharing your data.
We're not going to share your data.
But
now the other part of this is
if that's limiting them, because California is a very large part of the country.
So here's another comparison with GDPR, which is GDPR's obligations or preferences for consumers is opt in, while California's is opt out, which means that in Europe,
by the way, that is a huge distinction.
It's a huge distinction. In California, it means that in Europe, the default is that data is not being shared.
Proactively consent.
You have to proactively say, you may share my data. And in California, the default is you may share my data, and I can only opt out of it by proactively saying, I do not want you to. So if I don't, if I don't actually read that little thing that pops up every time I go to a website that says accept cookies or reject cookies or manage cookies.
Or choose my preferences, which is a whole nother screen.
Right. It shouldn't say manage cookies. It should say choose my preferences is what I think it should say. And it should allow you to say, here are all the rules associated with data, the use of your data.
It doesn't do that. The stock is tracking cookies, add cookies.
Yeah,
essential cookies. That's
essential cookies only. Yeah, essential cookies only.
That's another hot one.
It's obfuscating.
And if you say no, you're sometimes they won't even play. If no to all the cookies means
go find some other website to look
come back another time.
Yeah, come back another time when you want to play. So it's but that being said, it's because the ability to share data now combines this transference of obligations. And this is something that I think is a huge information risk, which is databases and data systems are not designed to be attributed with externally imposed obligations.
Yeah. So, and this is, I had a conversation recently with a CEO on my podcast, actually. And his position was, it was Shiva Nathan. And his position was that with the advent of sophisticated AI and quantum computing and the ability to basically decrypt almost anything and get basically access to almost any data, that he believed that companies will begin to opt out of housing data because data just represents a massive liability. There will be no way to protect it, as obvious by all the breaches that are happening now. Right now, there's no implications. It strikes me that there's just no penalty of significance to prevent them from wanting to house the data, because when they're breached, it's just, whatever, a few dollar fine for a large corporation, nothing significant. And on we go, doing effectively similarly reckless data management.
Yeah. So this is where I think a lot of people are getting these things wrong. It's that, like people will look at GDPR or they'll look at CCPA or CPRA and they'll say, oh, like the data management people will say, oh, this is a reason for doing data governance. And doing data governance, and we can talk about this on yet another episode, but doing data governance doesn't mean you are facilitating compliance with what the laws really mean. And it means that you are imposing a bunch of rules on internal use of the data without which this by necessity is also constraining your ability to monetize that data. And really what we have to look at is not how do we constrain and reduce the flexibility of using that data, but rather how do we build our systems to accommodate all the different requirements for observance of externally imposed rules. And it's not about ensuring data quality or making sure that you've documented a policy, because then that just becomes a bunch of checkboxes on a list, and you're still going to get hacked. The data is still going to get out. So it's not about that. It's about understanding, what are the true implications of these rules or these laws, and how do I understand how to interleave policy management within data management in a way that is both auditable and accountable. And I think this is, and so CEOs who are out there who are listening, or CDOs, this is where we need to talk, because most people are willing to just kind of devolve to the lowest common denominator, which is either, oh, we're going to get another tool, or we're going to just not stop sharing, as opposed to what a strategy would say, which is, we really need to understand what our data needs are and where the constraints intersect where our needs need to be filled. And then how do we impose the right level of policy management to ensure that we optimize our use of our managed information.
Yeah, and I will reemphasize that what I was talking about at the beginning, that there's national legislation currently prepared for debate. Make no mistake about it. This is a problem that is not going to go away, and it's not a problem that has an easy answer. And these are sophisticated strategic decisions and corporate tactics that have to be implemented in order to manage your way through this. And guys like David Lotion are the best kind of guys to talk to with regard to how to manage and navigate this very sticky data era that we're in. And so we'll wrap it up here, David. But there's so much more we can get into, and I want to get into all of the other topics that this propagates for the future of where data is headed, and honestly, I want to at some point explore the theory that we should all basically be remunerated for our own data individually as wherever we go, rather than having these websites kind of gather our data and then, for all intents and purposes, kind of arbitrage it off as, they capture it for a certain amount of money in terms of search costs and so forth, and then they sell it to somebody else as a lead. And we end up with nothing except effectively being a sales opportunity to somebody. This idea that we all represent a massively valuable cache of data ourselves that we should be monetized for anytime a corporation wants to engage with us. But I'm sure you'll have some thoughts on that. And I don't want to tee you up right now, but
no, certainly a fertile area for conversation. And I want to add on to that again. If you're listening and you've got a particular area of information risk that you want to drill into, contact me. We will get it on the docket and we will do an episode about it. So thank you very much for yet another fascinating conversation. I appreciate the time.
Yeah, David, thanks a lot. And we'll see you next at the next information risk episode.